I would like us to move to tribunals. Before we move to tribunals, any questions? So what are tribunals? Tribunals are established by law with specific judicial powers, and they issue awards. So you understand, a court can issue judgment, decrees, convictions, or acquittals. But a tribunal just issues awards. And they are cheap alternative to courts because parties represent themselves. They are subordinate to the High Court of Kenya. They're subordinate bodies. They're subordinate courts that fall under the judiciary. And appointments to these tribunals, for you to hear a matter brought before a tribunal, you must be appointed by the Judicial Service Commission and not the executive. So where do we start with tribunals? They are a machinery provided for adjudication rather than part of the machinery of administration. So you must understand that tribunals are statutory bodies. They don't exist out of nowhere. An act of parliament allows them to be in existence. So they also act within the powers vested unto them. They cannot act ultra vires. And they're established to deal with particular types of cases or a number of closely related cases. And they are set up to deal with these cases on a permanent basis instead of each time an issue arises, it's set up. So once the issue is resolved, that one is set aside and you wait for another issue. So they reach binding decisions, the awards they have, and what is the rationale? Is that they're cheaper. They have the accessibility. They are free from technicalities of the courts, and they have expert knowledge granted unto them. So in Kenya, our tribunals are set upon statute by statute basis without any common characteristics. So there are roughly more than 60 tribunals in Kenya, in existence in Kenya today. And some are called tribunals, others are called boards, others commissions, others authorities. And they are appointed and constituted differently. Some are set up by the president and the rest by the various acts of the government. And all of them exercise different powers. Some allow representation by advocates, while others don't. And some, the decisions are final, while others are appealable to the High Court. Remember that they are established under different acts of parliament. This is where I'm saying their structures are not as set out as rigidly as this structure of the court system in Kenya. they arise out of a need that can be determined repeatedly. And when we say some can appeal, some cannot appeal, their powers are set out in the acts that set them up. But the most important thing to remember about tribunals is that they are subordinate. And that means they appear below these three. They appear here in this subordinate category. So what are the advantages? We have talked of cheapness. They're cheaper than this court system. We have talked about accessibility. They're easily accessible, and they're not as technical. See, for you to appear before a tribunal, you must at the very least understand the happenings of why, because you can actually represent yourself. You must understand the subject matter of what is happening. As much as they have those differences, because they do not follow the strictly laid down structure, we appreciate that they come to offload the cases in this structure of ours. They enable justice to not only be seen, but also to be done. They enable it to move faster. And they give that aspect of hope that this matter can be heard, I can represent myself, I can argue and have my issues thought out comfortably. So we are on tribunals, the distinction between courts and tribunals. And we said Article 13C of the Constitution recognizes the judiciary and independent tribunals as state organs to which sovereign power is delegated by the people of Kenya. And this means that tribunals are for us. We, the people of Kenya, we delegate these powers to them to be able to deal with one issue or the other. So we have, we had said we have over 50 tribunals, 20 have been transited to the judiciary. So these are the 20 under the judiciary, coordinated through the Office of the Registrar Tribunals established by the Judicial Service Commission. So we have the Business Premises Rent Tribunal, established under Section 11 of the Landlord and Tenants Shops, that is Shops, Hotels and Catering, Cap 301. What you need to understand is that these tribunals cannot exist without a law, their delegated authority. So for them to exist, first and foremost, a law must have existed. And once this law existed, an issue arose. You see, we are talking about Business Premises Rent Tribunal. It exists under the landlords and tenants. So why does it exist? To protect the tenant from arbitrary eviction and exploitation, to ensure that the landlord gets return for his investment, conducive environment for business to thrive, issuing orders for levying distress in business premises, we talked about why we have laws and where subsidiary legislation comes from. It cannot exist from nowhere. An act of parliament must be in place. It is from that act that a tribunal will be established. We also have the competent authority that is established under Section 48 of the Copyright Act, Cap 130, and it hears decisions from the Kenya Copyright Board, unreasonable refusal to grant a certificate of registration, imposing unreasonable terms or conditions, and their clients are artists, musicians, or writers. We also have the Communication and Multimedia Appeals Tribunal, established under Section 102 of the Kenya Information and Communications Act. It hears complaints against any publications or conduct of a journalist. We have the Competition Tribunal, established under Competition Act. It has jurisdiction to hear and determine restrictive trade practices, exemption of certain restrictive trade practices, mergers and acquisitions. We have the Cooperative Tribunal, established under Cooperative Societies Act, Cap 490, and this one has exclusive and unlimited geographical and pecuniary jurisdiction to determine cooperative disputes among members, past members, and persons claiming through members, deceased. You see, when it says it has exclusive and unlimited, the territorial boundaries do not apply. You cannot say that I am in Kisumu and so the matter must be heard there. No, it's not limited. It also has no limit on pecuniary jurisdiction. You remember when we talked about the civil cases in magistrates' courts, they have limits. You can only hear up to these millions of shillings. So this tribunal does not have that limitation. And it also goes beyond living. If members of an estate, we talked about the administrative letters, they can actually be assisted because of this. They can go to this tribunal and the cases are claimed by a cooperative society for any debt or demand due to it from a member or past member, from the nominee or personal representative of a deceased member, a claim due to by a SACCO against a refusal to grant or revocation of any other license. So we also have the Education Appeals Tribunal, again, established under Section 93 of the Basic Education Act. Any person aggrieved by a decision of the County Education Board, discrimination relating to color, gender, age, tribe, disability, religion, denial of examinations. Remember the case where a headmaster took neck over the refusal, over the cancellation of the examination results? The Education Appeals Tribunal has jurisdiction to hear that. And as a student, as a teacher, as a trade union, all of them. Energy Tribunal, established under Energy Act, and appeals from Energy Regulatory Commission. We have also the Industrial Property Tribunal, resolution of disputes in different areas of intellectual property, Micro and Small Enterprises Tribunals, Section 54 of the Micro and Small Enterprises Act. So all these tribunals, you realize what they have in common is that they're established under an existing law. You cannot establish a tribunal without a law that was created to deal with one issue or the other. We also realize they're subordinate. None of them they have these ones that we have talked about, their appeals are heard by the High Court. Any issues arising out of them, they cannot just exist. They have law, they have regulations that are followed to the letter. We talked about the Judicial Service Commission, and this Judicial Service Commission, we talked about how they have the mandate and the power to set out and establish those that sit in these tribunals. So the Judicial Service Commission is established by Article 171 of the Constitution. It is composed of the Chief Justice, who's the chairperson, one Supreme Court judge, one Court of Appeal judge, one High Court judge, and one magistrate, a lady and a gentleman, elected by the members of the Association of Judges and Magistrates, the AG, Attorney General, one gentleman and one lady, advocates of the High Court of Kenya with at least 15 years experience, an individual nominated by the Public Service Commission, and a gentleman and a lady to represent the public. And not just, they should not be lawyers, but they should be individuals to represent the public. And they're appointed by the president with the approval of the National Assembly. The Judicial Service Commission is subordinate to the courts. And what are their powers? They act independently and delegate powers to its members. What are their functions? Under Article 72 of the Constitution, it promotes and facilitates the independence and accountability of the judiciary, as well as the efficient, effective, and transparent administration of justice. And how do they do this? They recommend the people to be appointed as judges. They also appoint, receive complaints against, investigate, and remove from office. They discipline registrars, magistrates. They discipline the staff of the judiciary. And they also advise the national government on how to improve the efficiency of the administration of justice by promoting gender equality. You remember that in its composition, they're insisting on a man and a woman, one man, one woman, to ensure this gender balance. We talked about the Attorney General, and his office is established by Article 156(1) of the Constitution. He's nominated by the President, and the National Assembly more or less interviews him for suitability. We have seen that in Kenya, where in the recent past, the Attorney General was replaced. So when the name was presented, he appeared before the National Assembly. He was queried, his suitability put to test, and he passed the test and thus was appointed. So what are his powers? This is the principal legal advisor to the government and represent the national government This is why when suing the government, it is the Attorney General that you sue. It's never blank, because this is the office that is mandated to ensure that the national government is represented in court or in any other legal proceedings to which the national government is a party. Talking about the court system. And in this court system, we now deal with the advocates, because it is the advocates who are appointed as the magistrate. The Attorney General himself must be an advocate of not less than 15 years of as a superior court judge. The basic training is that of an advocate. That is where you rise. So we will need them for this court system. It is them that enforce the constitution, them that follow the civil procedure courts, the civil procedure rules, sorry. You can represent yourself, yes, but you are advised to get someone who understands the law, someone who can explain what are the repercussions of your actions, someone who can defend you, someone who has been trained to appear before a magistrate, to appear before a judge, someone who will have your best interests at heart. So that is why we will talk about advocates here. And this is a person who has been duly entered in the role of advocate. And for the person to qualify, must be a citizen, hold a law degree, satisfy the Council of Legal Education, and that is go to the Kenya School of Law, have a diploma, and be admitted to the bar. So what are the duties? To the court. He is an officer of the court, and thus is bound to assist in the administration of justice by urging the law as it is. It is them we leave that burden of reading the Constitution, understanding that this matter that was heard before this magistrate did not follow the rules of law. That is why you're given a chance to appeal either against the facts of the case or the rule of law that was not followed. Who can assist you in doing that? That is an advocate. That advocate has a duty to its client. And that duty of care is where if you have someone representing you, they must do it to the best of their abilities. Duty to the profession. You must maintain the highest possible standards of conduct and integrity by observing the law and other rules, by making sure that you protect the Constitution in all that you do, by making sure that you uphold the Bill of Rights in our Constitution. So the duty to the society, you must assist its social, political, and economic development. You have heard of pro bono cases, whereby an advocate chooses to represent someone free of charge. It is part of their community social responsibility, giving back to the community. And the Law Society of Kenya maintain and improve the standards of conduct, facilitate acquisition of legal knowledge, represent, protect, and assist members of the legal profession, to raise or borrow money for its purposes, to acquire, again, subordinate legislation formed under the Advocates Act.